Hey class, it's Derek Lariviere here. This week's assignment is to create a 15 to 20 minute PowerPoint or video presentation as it pertains to our criminal justice system. I obviously chose a video presentation. I've got some notes and some things pulled up on my screens here. Wasn't able to memorize everything for the whole 15 minutes, so I might look away from the camera occasionally just to get some notes. But the assignment was verbatim to create a 15 to 20 minute PowerPoint presentation or video comparing the idea of our criminal law system as adversarial to other descriptions of how a courtroom works. Now, how I interpreted this was to interpret how our court system works and to kind of juxtapose that with the ideological aspect of the court itself. For example, some negative things happen in courtrooms that, if you look, for the way the court is supposed to run, don't quite mesh up. Sometimes the ideas of how a court is supposed to work don't match real life, and that's kind of the route I'm hoping to go with, and I hope that is the correct assignment. The question was a little confusing after the reading, but I think that's what it was aiming towards. So, without further ado, let's get started. Let's get started with the definition of some of the things. The justification for law is a prevention of harm. So in this country, our court system's foremost, priority is, or the legal system, I should say, is the prevention of harm. And so in that, we have created a system where everybody sacrifices a small amount of liberties, and in return, we are granted protections from others who are also in the same boat that we are in. And what's interesting about this is it kind of spurns into the idea and how people view the courts. Now, in our country, our court system is a system that impartially interprets laws and metes out justice. Now, what does that mean? Laws are written by Congress, put through the Senate, and ratified into law by the president. In addition, that's federal law. There's also state law that follow a similar process with state versions of those bodies, Congress, Senate, and state representatives, state senators, and then the governor. Now, when it comes time to interpret these laws, that's where the court comes into play, and that's where judges and juries come into play, and judges specifically. The role of a judge is to be an impartial agent of the court, and what they do is they look at the law as it's written, they interpret what it was intended to do, and then they mete out a punishment in response to that. Now, that's the main purpose of a judge. Thinking along that line, it's important to point out that judges don't always do this. Sometimes judges aren't impartial because they have either political motivations or a poor moral compass. And now lots is put into, depending on whether the judge is elected or appointed, and the review process and what level of court they're at, a lot is put into ensuring that this does not happen. But it does happen, and it happens across the board. And I'll get to that a little bit later because it's something interesting I want to point out when it comes to the Supreme Court that we have in our country. Let me just check through my outline here. All right, so let's talk about lawyers for a second now. Lawyers are officers of the court, first and foremost. They're, depending on what type of lawyer you are, whether you're a prosecutor or whether you're a criminal defense lawyer or a civil lawyer, your goals might be different, but at the base of it, you are an officer of the court. And what a lot of people don't actually realize is that, for example, criminal attorneys and prosecutors often work together. In fact, they work together on and off the books. And they work together in the back room, and they try to get the best, the criminal defense attorney tries to get the best deal for his client, and the prosecutor tries to do what's in the best interest of the public. And those don't always mesh up either. But it's also important to point out that as lawyering has progressed as an actual recognized profession, early on, according to our text anyways, lawyers weren't allowed to charge because they viewed it as kind of a mercenarial act. And so that's interesting as well. And that kind of plays into the base of understanding of how the court works. But here's where adversarial, I think, elements start to come into play. And that is essentially the system of the court is that two advocates of equal ability are supposed to engage in the pursuit of truth, and the whole thing is guided by a neutral judge. And so what that means is that on the one side you have the prosecutor in most criminal cases, and all criminal cases unless it's a grand jury. You have the prosecutor, and then you have the defendant. And what they're supposed to be on equal footing. Everybody has the same information, everybody's roughly trained the same, everybody has the same resources. And then they bring their case before the judge, and the judge is an impartial or neutral person, and they decide the outcome. And I feel like this specific action of the way the court system works in our country, our criminal law system, is where you'll see a lot of adversarial stuff that comes into play, and that's what I want to get into right now. So let's get to the meat and bones of it. There's some major kind of bullet point problems that need to be discussed when you're talking about putting our criminal law system up against how a courtroom works. And problem one is monetary. The fact is not everybody's equal. And in fact, there are several instances where your economic standing can directly influence whether or not you are basically guilty or not, and what kind of sentences you can receive. Now, there's an interesting study, and this is going to be listed in my reference, but it's from an article on The Guardian, which is kind of a politically motivated paper. However, the source material is accurate. And what it says is, among defendants arrested in 2008 on non-felony charges and given bail of $1,000 or less, only 13% of defendants were able to post bail at arraignment. So, in other words, 87% of those go to jail. They go to jail and they await trial. And what this does is it puts those people in a position, and directly because of their economic status, where instead of being able to be free in society and work on their case and continue on with their family life for what is assumedly a relatively minor crime with $1,000 bail, they are in jail, and sometimes they have to wait there for months to get seen by a judge. This is important because it highlights one of the foundations of some of the monetary inequalities and some of the breakdown between criminal law and the courtroom. Essentially, it's I don't know what you would call it, perhaps economic punishment. So that's interesting. And another monetary thing that's interesting is whether or not you get a public defender or you can afford your own attorney. And if you can afford your own attorney, what kind of attorney can you afford? You look at your Robert Shapiro's in the O.J. Simpson trial, and he's very high profile. He basically got somebody off with murder, if you ask most people, and he paid a steep price for that. So O.J. did. In addition, you have your middle-of-the-road lawyers who are able to devote a significant amount of time to their clients' problems and fact-check things and do things that a public defender simply might not be able to do because of the fact that they have to take on so many cases. So poor people are at a decided disadvantage in our court system. Now, criminal law and the theory behind it is that everybody should have a fair say, an equal trial, but that's simply not the case. And so that's the first kind of adversarial thing that I wanted to talk about. The second problem can be related to the first problem, but not always, and that's racial. I read a study called Sentencing Convicted Juvenile Felony Offenders in the Adult Court, the Direct Effects of Race. And what this study did was it looked at different data points, and it corrected, it was a very well done study. It corrected for different data points and legal and non-legal, factors, and it determined that by and large, African American or black minorities are much more likely to be sentenced to jail time than their white counterparts. This is interesting because it also showed that white people were much more likely to get bail offered to them, or I'm sorry, not bail, probation offered to them, as opposed to their African American counterparts, instead of jail time. And the reasoning behind this is kind of a muddy thing, but Part of it has to do with the breakdown of who is a judge in this country, who are the people, who are the prosecutors, who are the judges. And, predominantly these people are white, they're Caucasian. Now, obviously there are, African American and Hispanic judges and prosecutors, but it's a very male white dominated, like most things, business, and very dominated by white males. And so there's, obviously prejudices that can exist within those things. And, when you see a young black person come in from a potentially poor neighborhood, let's say, apologies for that. Poor neighborhood, let's say, that person's going to be viewed differently than a young white suburban kid. And so, again, we're going back to the adversarial difference between, the fair shake for everybody, the criminal law system, and how the courtroom works. So, a lot of the ideals of the courtroom don't necessarily play out the way that you think that they should when it comes right down to it. Let me look at my notes here one second time here. Let's touch on the public defenders as well. So we have this concept of this equality on both sides of the equation. We have, your prosecutor and your defense attorney. All defense attorneys are not created equal. And in fact, a lot of very highly paid defense attorneys can be much more effective in several cases than prosecutors, because they have, in certain cases where money is no object, they can essentially have their entire law firms combing through files and finding, deep hidden legal case law precedences, and, reviewing the evidence for and having paying expert witnesses. And that's one thing I want to touch on was expert witnesses. Public defenders aren't paying for expert witnesses. They're not having people come in and, by the troves and convincing the judge and the jury that their client's innocent. So, when we go back to that, I feel like that's truly one real adversarial thing between the two. So that's a big one. And then I'd also like to touch, lastly, when we're talking about these portions of it, on judges. Judges have a model code of judicial conduct. I'm going to look at my notes here for a second, because this was the part I was having trouble memorizing. And it identifies the ethical considerations unique to judges. It's organized into 4 canons, as the book says. And one of the primary ethics, the primary theme of the ethics is impartiality. And so let's talk about judicial impartiality for a second. We've already discussed, how judges can sometimes do the wrong thing. I think one of the first things we should look at with this is simply just to look at the Supreme Court. Historically, the Supreme Court has not always had a very strong history of deciding cases on a 5-4 basis, because keep in mind right now we have, Justice Kennedy, he's kind of a swing voter. He's kind of the wild card, let's say. But we also have, the Chief Justice, and we have more conservative judges than we do liberal. Now, my political views aside, and hopefully everyone else's political views aside, this is not a very good thing. Historically speaking, and I'll reference this at the end as well, most cases that are overturned are 5-4 decision cases. And not since the 1930s, I believe it was, have we seen cases in this amount that are decided 5-4. Traditionally, the cases had a much broader, 6-3 or 7-2, very simple cases, easily decided. But the Supreme Court, is essentially politicized. The people are appointed because they'll best represent the president who's appointing them for now and in perpetuity until they, as we all know, the Supreme Court justices can't be fired. They have to retire, or, so we have that. And that's a big issue. So politically speaking, I'd like to take a look at the Affordable Care Act, and that came before Congress in 2012 as being unconstitutional. And what you would normally think would happen here, let me just get my facts straight real quick. John Roberts, Chief Justice John Roberts, he normally would side with the conservatives. I mean, that's generally what he does. But he's even spoken out about this politicization. And the 1930s really was the last time somebody struck down this sort of presidential, law or whatever, driven by the president. And he didn't want that to happen, so he actually sided with the liberals on this, and he said, yeah, it's fine, even though there was a dissenting opinion from the swing voter, Kennedy, who usually would side with, not anybody, he's a swing voter, but he sided with conservatives on this, and he said that it's in and of itself unconstitutional. But in any event, it was a 5-4 decision, but not the way you would think it was. So I thought that was an interesting point to point out as well, that it's not always a faulty system, depending on your political views, of course, but, judges aren't, even though they're supposed to be impartial, they're not always. And then you have to think, what sort of example is the Supreme Court setting for lower courts? When they're heavily politicized, and that's plain as day for anybody to see, I don't really feel that needs much of a reference. That's not something you can reference from an academic journal or something. I mean, you just simply have to look at the Supreme Court and the decisions that it has made, and see that they fall very neatly along political lines and who was appointed under what president and what political agenda. It's very clear. So taking that as just kind of a de facto thing, you have to look at what does that set for lower judges, and then you get into an interesting phenomenon called legislating from the bench, which is where judges will interpret the law in a manner that suits their political agenda when it's a hot button issue, and this invariably sends this, a lot of times these are appealed and things result, gay marriage, for example, racial issues, a lot of these hot social issues kind of get legislated from the bench from time to time, and, state judges and federal judges in states will push these up into higher courts, and eventually the Supreme Court will decide on it, but, these people will essentially stop things from happening that have been voted into law, such as gay marriage. For example, it's happened in several states where gay marriage laws were passed, and then judges said nope, and then obviously the Supreme Court's going to deal with that. So that's an interesting way to think. And then other things I want to point out with judges is potential racial issues they have. A lot of judges might have some prejudices against people, and this will play out in the courtroom. So, all the things I've talked about so far kind of reference the difference between what the court system should be and what it is, and what the criminal law system should be and what it is because of our courts. Criminal law should allow everybody a fair shake, a fair trial, but it doesn't always. And I've kind of addressed some of the reasons why. And it's an interesting thing to think about. And one of the other things I wanted to point out, let me just check my notes again one last time here, is public defenders. I wanted to talk about something that the Missouri Public Defender Commission did. They've actually allowed public defenders to turn down cases based on caseload. And it's these types of actions that I believe will allow people to kind of overcome these adversarial positions between criminal law and the courts, where everybody should be getting a fair shake, and sometimes the poor can't because they can't afford it. This is a step towards kind of rectifying that, and I think it's a good example for other states to follow. Some of the things that they've done, let me just look at some of the other things they've done here. They've increased the funding for the public defense. They've increased the ability for public defenders to make proper decisions when it comes to their clients. So just to kind of summarize, criminal law and the courts aren't always seeing eye to eye. Judges interpret the criminal law system, and they're ultimately responsible for determining what laws mean. So while somebody may have been arrested for breaking the law, it is then up to the judge to look at that and say, well, did they break the law? Here's the evidence. What was this law intended to do? Was it intended to put this father of four into jail for this amount of time, or was it intended for more serious offenders, and was it intended for first-time offenders? And so that's why some of the things like three-strike laws and other things that are kind of unfair to people are not really generally well liked by judges. They like to have the ability to interpret those things, and with that comes the inherent possibility that they will interpret it wrong, and it will have to go to a higher court for review. So that is my week's project. I hope you enjoyed it, and I hope you agree with me. And above all, I hope I interpreted the assignment correctly. I believe I did. So thank you very much for watching, and Merry Christmas or Happy Holidays. Have a good one.